What I would say, though, is we do expect to have our preliminary injunction filed soon. And we do expect the state has agreed to oppose by December 1st. And we're confident that Judge McGlynn will reach a ruling on that ahead of the January 1st deadline.
That's Costas Morris. He is a associate attorney with Mitchell & Associates, one of the law firms representing a whole bunch of gun ban plaintiffs. Good morning on this Monday after Friday, with the Seventh Circuit U.S. Court of Appeals siding with the state, saying that the state has a likelihood of succeeding in the merits of the challenge against the state's gun and magazine ban. Welcome in. It's Bishop on Air. I'm Greg Bishop. Thanks for hanging out with us each and every weekday morning, and wasn't anticipating the Friday ruling, but it did indeed come out, and something that I think caught some people off guard just because we've been waiting for 4 months. They heard the case back in June, and then on Friday, the Seventh Circuit U.S. Court of Appeals decided to go ahead, went ahead and ordered that they are vacating the lower court's ruling of a preliminary injunction that they stayed back in May. So let's just take a step back. We'll hear what Costas Morris had to say when I chatted with him over the weekend. And again, he's one of the attorneys representing plaintiffs in the gun and magazine ban case. And we'll also hear from Costas about the ongoing litigation in the Southern District. So just take a step back here. All right, how did we get to this point? January 10th, Governor J.B. Pritzker here in Illinois enacts a ban on 170-plus semi-automatic rifles, shotguns, and pistols, and bans on magazines of capacity of 10 or more or rather more than 10 for rifles and more than 15 for handguns. So that was enacted on January 10th. The measure also requires that by January 1st of 2024, those who owned these firearms before the January 10th deadline must register them with Illinois State Police. And that registration is something that obviously is got a lot of people stirred up a bit. So let's go ahead and fast forward. You got lawsuits filed in the Southern District and the Northern District, and you've had the different districts consolidate cases and the challenge of the Second Amendment. Northern District judges sided with the states on local bans, including Chicago and Naperville, but also the state bans. And then the Southern District, Judge Stephen McGlynn, he filed a preliminary injunction back in April. And essentially, it halted the law from being enforced. So after that, 6 days go by, the state goes to the Seventh Circuit Court of Appeals and appeals the Southern District ruling, to which the Seventh Circuit said, you know what, we're going to take the Southern District cases and the Northern District cases, are going to lump them together, and then we're going to have briefings and a hearing. The Naperville case went to the U.S. Supreme Court to say, hey, we need an expeditious result here. Please take this case. And the Seventh Circuit said, no, we're going to expedite this. So Supreme Court said, okay, they're going to expedite this. Seventh Circuit expedited a hearing, but then they, for 4 months, sat on the ruling until Friday comes out. Now, before the ruling came out, you had some action back down in the Southern District because the plaintiffs' groups were taking different elements of their cases that went all the way to the appeals court that weren't argued and bringing them back to the district court. All right, so you had Thomas Magg. Back in October, he brought the vagueness question. That was heard. We're waiting for Judge Stephen McGlynn, who had previously issued a preliminary injunction in the Second Amendment question. We're waiting for Judge Stephen McGlynn to issue some kind of ruling on the vagueness question. But then you had the Federal Firearms Licensees of Illinois bring their challenge, and they're wanting to amend their complaint to essentially say you have to, block the January 1st deadline. And there's irreparable harm that's possible. There's no due process, and a variety of other arguments. So they were allowed back in the Southern District to amend their complaint, and they were set to file a preliminary injunction motion on Friday when all of a sudden you get that ruling. So from Mitchell & Associates, here's Associate Attorney Costas Morris, who you may follow on Twitter. I connected with him over the weekend, and we talked about really just his initial reaction to all of this.
Costas Morris, I represent Federal Firearms Licensee of Illinois, Gun Save Life, Gun Owners of America, Gun Owners Foundation, and Piazza Armory. Support them all. Now, as to the appellate ruling yesterday. It was disappointing, but not surprising. So once we found out the panel included Judge Easterbrook, who was reversed in McDonald and wrote the Friedman opinion, I believe, we knew it was going to be an uphill battle. And although he didn't write this appellate ruling, it was actually Judge Woods. You can see Judge Easterbrook's fingerprints all over it. And what they did was kind of shocking, because even the lower courts that upheld the law said Friedman, the last ruling on this topic before Bruin, was no longer good law in light of Bruin and had to be reanalyzed. But this appellate ruling said, actually, no, Friedman's still good law, and they just simply seem to reaffirm that. And perhaps the most stunning thing they concluded was that rifles are not arms under the Second Amendment because the banned rifles, because the military uses them. And that standard has never made its way into any Supreme Court precedent, or frankly, any other case I've seen. Even anti-Second Amendment rulings have not concluded quite that much. What they typically say is certain weapons that are only useful to the military, maybe your Stinger missiles, ordnance, things like that, are not covered as bearable arms that are in common use by citizens, so they're not protected by the Second Amendment. But nobody's ever said they aren't arms under the Second Amendment. It's just that the historical tradition allows you to restrict dangerous and unusual weapons. And the absurdity in this approach is apparent, but I think someone commented on Twitter yesterday, I forget who, I apologize, but it stuck with me. They said, by this approach, muskets in 1791 could be banned because the military used muskets in 1791. So the Second Amendment would literally not apply to muskets under Judge Easterbrook's military-only approach. So that was a stunning ruling in that regard, and I'm sure we'll see what the next courts happen to think. Now, we're still considering whether to pursue Supreme Court review. That's going to be a decision made above me, but that's certainly something that I think the Supreme Court will have to deal with eventually, be it now or after a final judgment.
So again, a conversation I had with Costas Morris over the weekend, and those next steps are very much a question that people want to know. What's going to happen here? He mentioned the U.S. Supreme Court. You do have some of the statements that were released over the weekend from the Illinois State Rifle Association in particular. Let's check out what they had to say, because they went on to say that they are going to take this to the U.S. Supreme Court. They said it's always been and is our intent to take our case, and this is a separate plaintiffs group than the FFL of Illinois. The Illinois State Rifle Association says they do intend to take the case to the U.S. Supreme Court, where they say we believe we can get a favorable ruling for law-abiding gun owners in Illinois. We will continue to stand up for the Second Amendment and Illinois law-abiding gun owners and against our anti-gun Governor Pritzker in General Assembly. We will be working with our attorney to take the appeal to the U.S. Supreme Court. Federal Firearms Policy Council, they went on to say on Twitter that there's still more to be learned about the case as it moves forward, leaving the door open for victory. They say that they're reviewing their options and they plan to respond accordingly. But again, when talking with Costas Morris, the U.S. Supreme Court obviously is one option. What happened Friday came from a 3-judge panel, all right? Not the entire Seventh Circuit Court of Appeals, which is an option. That's en banc. Or they could take the question on the merits back to the Southern District. Because here's the key here. This was just on the preliminary injunction, and this was something that was made clear in the appeals court's majority opinion. They essentially said the state of Illinois, in the litigation that lies at the heart of the case, has decided to regulate assault weapons and high-capacity magazines, a decision that is valid only if the regulated weapons lie in the military side of that line and thus are not within a class of arms protected by the Second Amendment. While they made that in their filing, in their order, it wasn't necessarily about the merits, the ultimate outcome. The ultimate outcome was just a vacation of the preliminary injunction that they stayed back in May from Judge Stephen McGlynn he issued in late April. So that was really what the ultimate outcome was. But the next steps here, U.S. Supreme Court review, full panel of the Seventh Circuit Court of Appeals, or going back to the Southern District. Again, here's Costas Morris with some of those ideas of what happens next here.
So again, it's not my call. I'm an associate with Michelle and Associates. I'm not the senior associate. That's Chuck Michelle, and it's also going to be the clients will decide. So everything's on the table right now. I don't know which way we're going to go yet. We're probably going to discuss it early next week after having digested this ruling. But yes, in bank is an option if we want to. If we en banc, if we want to go that route. The Supreme Court is an option, and with so many sets of plaintiffs. I don't know what level of coordination there's going to be yet, but maybe different groups will try different things. We'll see. Yeah.
Well, another question I had for him was about, again, explaining what the ultimate outcome was from Friday's ruling, right? Was it preliminary injunction? Was it based on the merits of the case? Ultimately, what's an attorney's interpretation of what happened on Friday?
Right. Well, to be clear, on a preliminary injunction, they are judging who they think is more likely to succeed. So they did do a Second Amendment analysis, kind of. I didn't think it was a very, faithful to Bruin analysis, but their conclusion was we believe it's much more likely than not that the government will succeed. However, they did leave the door open that with a more complete record after a judgment in McGlynn's courtroom or the other courtrooms as well, that could change. Following more development of the record. The main thing they seemed to do in this opinion, though, was they really just talked about the AR-15, and that's interesting because although that's a very high profile firearm and we certainly think it should be protected, this ban covers a lot of shotguns, a lot of handguns, a lot of rifles that are not AR-15s, like certain models of Ruger 1022s could be are affected. So it was interesting that they focused in on this one thing and seemed to ignore all the other arguments. They could have reached a more split decision saying, it might not protect AR-15s, which we still think would be wrong, but it does protect these other common shotguns and stuff that end up being encompassed in this ban. And I think the dissent pointed that out too.
So the dissent, he also talked more about in as much as just what was all in that dissent. It's important when you hear and read these opinions that come out, even out of the U.S. Supreme Court. Don't just look at the majority opinion. Look at that dissenting opinion, and you get a general idea of just all the various arguments there are. So while the majority opinion from Judge Wood and Easterbrook essentially, said, hey, the state has a likelihood of winning on the merits. We're vacating the lower court's preliminary injunction. But the Second Amendment has limits, just all freedoms have limits, they say. And they go through and talk about military weapons and, the civilian weapons and so on. But what was the dissent's take on the case?
He seemed to, yes, I think the dissent was longer than the majority opinion, actually. But I read it yesterday, and he seemed to be exasperated with a lot of these arguments. Like the point about these not being arms is, frankly, as he saw too, ludicrous. No matter what you think about whether they should be protected by the Second Amendment under historical tradition, they are arms, because Heller defined arms as weapons of offense or armor of defense, or by another dictionary from the era, anything a man taketh into his arms to cast at or strike another. So anything, even an M16, even a machine gun, is an arm. You then proceed to the second question of the historical tradition, and that's when you figure out, are these, can these be banned because despite being arms, maybe they're dangerous and unusual, or these other historical concepts that exist to allow some restrictions on the right to bear arms. But the Seventh Circuit didn't even want to acknowledge that much. And their definition of arms, as the dissent commented, that they can be restricted to things that the military has never used, is ridiculous. I think the dissent gave the example of the M9, which the military used as its standard sidearm for about 30 years, I think, something like that. But for 10 years before it was ever sold, before the military adopted it, it was available on the civilian market. It's a very common handgun. Does the military adopting it suddenly make it not an arm under the Second Amendment? It's a ridiculous argument, also because at the time of the founding and until the 20th century, really, civilians had better arms often than the military. Like in the Civil War, people would some people could afford to buy the then new Henry repeating rifles, whereas most of their fellow soldiers would have these single shot rifles. So it's never been the standard that something being a used by the military means it's unprotected by the Second Amendment. In fact, it's quite nearly the opposite. For a while, commentators in the 19th century said that arms that are used by the military are the ones that are protected by the Second Amendment, whereas maybe there's more leeway to ban things like pocket knives and small concealable pistols, but you can't ban the large revolvers and the rifles and such that a soldier would use.
So again, he clarified on Twitter after we chatted about this, and I published a story. He said that they could ban the carrying of certain types of pocket knives or small pocket pistols type thing. There's a historical precedent for some of that, but ultimately he says that the Second Amendment was historically believed to be to protect those arms that even the military could have. And he, as you heard, the part of the dissent talked about a pistol that was on the civilian market for a decade or two before the U.S. military decided to go ahead and make that a kind of standard issue sidearm. So interesting to hear some of these arguments. Now, next steps, of course, you've got David Siegel with the Illinois State Rifle Association saying that they're looking at their available remedies. You even have Dan Eldridge from the Federal Firearms Licensees of Illinois saying that they haven't made a determination yet, and Costas Morris, being an associate attorney for Mitchell & Associates representing FFL of IL, saying that they're going to be regrouping this morning, starting to see what those next steps look like. Are all these plaintiffs groups going to stick together? It's a big, important question. But all that's with the Seventh Circuit Court of Appeals. What about that motion to amend their complaint in the Southern District in front of Judge Stephen McGlynn that they were granted last week? And they were preparing to file that preliminary injunction, which could set a stage for McGlynn to give another preliminary injunction for this, to delay that January 1st deadline for people to register their firearms or face criminal penalties. Here is Costas talking about what they're doing back in the Southern District now.
Yeah, so we were just about to file on Friday our second motion for preliminary injunction to try and stop registration, but we decided to hold off for now because we just got this ruling out of nowhere on Friday. Not out of nowhere. I mean, we knew it was coming. We just didn't know when. So now we're going to take a pause real quick just to see how it affects our arguments. My initial impression is it doesn't, because although they obviously upheld the law for now, it's only on a preliminary basis. And as they mentioned a couple times in their ruling, it could change later. So we still think our Second Amendment argument as well as our due process arguments are valid. I mean, the due process arguments are still viable no matter what, because the Seventh Circuit didn't even talk about vagueness or any of that. But even the Second Amendment argument, I think we argue that there's no historical tradition of registration. And while we might have to now adapt that a bit to explain why the Seventh Circuit ruling doesn't kill that argument for now, which we'll do, I still think it's very much viable. Yeah, because that's important, because otherwise registration is going to kick in, even though now there's either going to be Supreme Court or en banc appeals or both. Illinois will not pause the registration. It would have been reasonable if they were willing to, pass a quick amendment to the law saying, let's delay registration a year so we can see how these cases shake out. We think that would have been the reasonable move, but they're not doing that. So we were left with no choice but to amend our complaint and bring this motion.
So again, that's Costas Morris with the Mitchell & Associates talking about the efforts down in the Southern District to try to bring about another preliminary injunction to halt it from going into place, because January 1st is coming, and a lot of people are concerned about that.
What I would say is I can never advise anyone to break the law, and I never would. I don't want anyone to get in trouble. What I would say, though, is we do expect to have our preliminary injunction filed soon, and we do expect the state has agreed to oppose by December 1st, and we're confident that Judge McGlynn will reach a ruling on that ahead of the January 1st deadline. So if people want to wait until the last week or two to register in order to see the result of our motion for preliminary injunction and see if maybe Judge McGlynn enjoins it, they can do that. Now, of course, I will caution that we could very well prevail with Judge McGlynn and then have the Seventh Circuit tell us to pound sand and just reverse that and force everyone to register. So that's a possibility. And again, I would never encourage anyone to break the law here. If you want to protect yourself, if you own one of these rifles, then frankly, the only safe route is registration. And I'm ideologically opposed to it. I think it's against the Second Amendment. That's why that's why we amended our complaint. We're arguing it. I just don't want anyone to get in trouble on account of a protest action.
So again, while the Seventh Circuit Court of Appeals Friday issuing their opinion saying that the state's likely to succeed on the merits of the case, the next steps here are still unclear as to if the plaintiffs groups are going to band back together and go to the U.S. Supreme Court, go to the en banc panel of the appeals court, or go back to the Southern District, while you still have this question of vagueness from the Thomas Mag case still pending in the Southern District, and you have FFL of Illinois and others looking to bring about a injunction to block the January 1st deadline from going into place until all of this litigation plays out. Final thoughts from Costas Morris.
No, just other than please go ahead and support our plaintiffs in this case. They're the reason we're able to bring it. That's the Federal Firearms Licensees of Illinois, Gun Save Life, Gun Owners of America, and Piazza Armory. So please support all of them. And stay tuned. I know it was very dispiriting to get this ruling, but frankly, it was not a surprise. We all expected it once we saw who the panel was. That's just the unfortunate reality. Both the two majority justices on the panel do have a history of, opposing Second Amendment rights. Judge Easterbrook denied there was an individual right to bear arms, but previously. So this shouldn't be surprising, and we do think at the end of the day that our position and Judge McGlynn's original ruling will be vindicated. Hopefully it'll be sooner rather than later, but regardless, we do think we'll win in the end here.
So there you go. Costas Morris, want to thank him for taking the time with me over the weekend to provide the reaction to give you that update. All right, stay tuned. Much more. It's Bishop on Air. Like, subscribe, hit that notification bell.